Hey guys, welcome back to today's video. Today we're looking at a Moorish sovereign citizen in child support court who refuses to recognize the system because he believes it makes him responsible for over $10,000 in unpaid support. Before we get into it, thanks to Old Squishy Gardener for finding this case, and to today's sponsor Aura. Recently, a major bank data breach exposed sensitive personal information like addresses and IDs after an unsecured container was left outside, and the data circulated for months before anyone noticed. Studies show breaches often take a long time to detect, which is where Aura helps by monitoring the dark web, alerting you to leaks, and tracking suspicious credit or account activity. They also offer identity theft insurance and security tools in one app.
This is an original petition and suit affecting the parent-child relationship with an acknowledgement of paternity, and this was filed by the Attorney General's office on December 6th of 2024. All parties are present on Zoom today, and this is a remote proceeding, and I am sitting outside of Galveston County pursuant to the Texas Family Code, Section 201.1045, and I find nobody has objected to proceeding in this manner. Mr. Millard, can you state your full name for the record, please?
Yes, my name is Sidney Millard Bay.
Have you legally changed your name?
Yes.
Okay, so you have a social security card with Bay? And
No.
Okay, do you have a driver's license with Bay?
No.
Do you have a birth certificate with Bay?
Ma'am, I challenged jurisdiction and we
Yes, and that
haven't.
was denied, sir, so we are proceeding.
Well, I'd like to proceed to a de novo hearing.
Have you filed that request with the court?
I did. It should be in your paperwork.
Judge, I don't see a de novo filed on Odyssey.
Don't either. You filed that with the district clerk's office?
I did. It was mailed on the 26th.
You might not have received it yet.
It should have been there.
When did you mail that, sir? You said the 26th?
Yes.
Is that timely, Mr. DeHimation?
No, Your Honor. Typically, de novos are done within 3 days of a judge's ruling. There hasn't been a substantive ruling in this case. But there's nothing e-filed on Odyssey regardless. The only ruling in this case is that his lack of jurisdiction was denied.
And before we begin, let me swear you in, sir, because even what you just said to me was not said under oath. So again, your legal name is, what is your legal name, sir?
Sidney, capital SIDNEY, Millard, capital MILLARD, Bay, capital BEY.
Are you the person who also goes by Sidney Somerville Millard IV?
No.
That is not you? That was never you?
That is my all caps name. That's not the name that I have.
Are you saying that's a different person, though?
No, I'm saying.
If you're not the person involved, then why did you join the Zoom hearing? You can exit the call now. For those who don't know, a de novo review or hearing means from the beginning in Latin. In legal terms, it refers to a higher court reviewing a case or issue fresh, without relying on the earlier court's decision or giving it any special weight. It is usually requested after a ruling has already been made, which is why asking for it at this stage would not be appropriate.
Sent a de novo to the state, but he hadn't filed it with the court.
Sir, where did you mail? Well, if you can both please raise your right hands to be sworn in. Do you each solemnly swear that any testimony you give today will be the truth, the whole truth, and nothing but the truth?
I affirm.
Yes.
Okay. So, sir, where did you mail your request to on April 26th?
I mailed it to the Lamarck office.
Okay, so you did not file it with the court. Mr. DeHimation, are you able to read what it was? I just want to make sure it was a de novo and not a new trial.
Yes.
Judge, I can share the screen if you would like.
I asked you to read it.
Okay. So the title, it's non-standard. The title he wrote request for de novo hearing. Then he's got his name, and he's got an address, and underneath that he's attempted to put a style, and then he titled it nunc pro tunc, and then underneath that he's got request for de novo. Then he's got another title saying notice to the court, requesting de novo hearing concerning the denial of my affidavit of fact of dismissal of lack of jurisdiction. I am requesting de novo hearing on the following grounds. And he cited several cases. Which is not relevant. And there's a page 2. And he's talking about the post box rule, which is also not relevant. And then he signed it on page 3, and he's got a jurat.
Objection.
What's
I
your
believe,
legal objection,
I believe
sir?
that everything here is relevant.
I'm going to sustain your objection. However, I don't know if it's denying, but I'm going to find that your de novo request, I don't need to wait for that because it was not filed with the court, and it was not filed timely, even if I considered the AG's office the court, which I do not.
Can you repeat that? I didn't
You did not file it with the court, and you did not timely file it, even if you had filed it with the court. So we're moving forward today. Mr. Dehamajian, you may call your first witness.
Thank you, Judge.
Well, hold on, Your Honor. I have a question. Like, you saying that it wasn't in a timely manner, but it was on the 26th, and notice to agent is notice to principal. Notice to principal is notice to agent.
The judge points out that the document was not properly served to the court, only sent to the prosecutor, so the issue is not even before her. Because of this, it is both untimely and incorrectly filed. The court then moves on to testimony, but the mother's statement is skipped as it adds little to the case. It is noted that the child is 13 years old and only about $3,300 in child support has been received so far. The focus then shifts to the next witness, who will testify about the total amount of back child support owed.
Well, it's not even filed. I'm finding it's not filed with the court, and it is not timely. You may proceed, Mr. Dehamajian.
Thank you, Judge. Judge, at this time, the state requests that you take judicial notice of our petition filed on December 6, 2024.
I take judicial notice of the pleading, including the acknowledgement of paternity that was signed by both parties with their all caps names.
Your Honor, I call Miss Tatiana Young-Fleeton. I don't know if she's been sworn in yet, Your Honor.
Don't believe she has. Can you state your full name for the record, please?
Tatiana Young-Fleeton.
And can you please raise your right hand to be sworn in? Do you solemnly swear that any testimony you give today will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you. You can lower your hand. Proceed.
Thank you, Judge. Ms. Fleeton, who do you work for, ma'am?
The Office of the Attorney General.
Ma'am, what did you calculate in this case?
Retroactive child support.
And what were your findings there?
For the year 2021, minimum wage, gross $1256.67, net $1159.87 for 12 months, at a total of $232 a month, based on 20%, for a total of $2,784. Excuse me. For 2022, minimum wage $1256.67, net $1159.87 at 12 months, at a total of $232 based on 20%, for a total of $2,784. For 2023, gross minimum wage $1256.67, net $1159.87 for 9 months, at a total of $232 based on 20%, for a total of $2,088. Also for 2023, for 3 months, gross $2,119.80, net $1,870.66. For 3 months at $374 based on 20%, for a total of $1,122. For 2024, gross $4,092, net $3,457.80 for 3 months at $692 based on 20%, for a total of $2,076. For 2024, minimum wage, gross $1256.67, net $1159.87 at 9 months at $232 based on 20%, for a total of $2,088. And for 2025, gross $1256.67 minimum wage, net $1159.87 at 4 months at $232 based on 20%, for a total of $928. The subtotal $13,870 with a credit of $3,300 for a total of $10,500.
Yikes. The total comes out to $10,570 in unpaid child support. That is a very large amount and clearly creates a serious financial burden. It shows how quickly arrears can build up when payments are missed over time. For many people, this kind of debt would take a long time to clear and would require a solid repayment plan. The situation highlights how important it is to stay consistent with court-ordered support obligations. This kind of case shows how enforcement actions can escalate when payments are ignored for a long period of time. It also emphasizes the importance of keeping accurate records and responding to court orders on time.
Based on Ms. Fleeton's testimony.
Don't see the case is even open for today. I don't have any objection to me entering the exhibit. What was it, State's Exhibit?
1, Your Honor.
State's Exhibit 1?
Yes.
Ms. Blake, do you have any objection to State's Exhibit 1?
No, ma'am.
And Mr. Millard, do you have any objection to State's Exhibit 1 being admitted into evidence?
I do object.
What is your legal objection?
My objection is that I don't wish to contract. I don't have a reason to contract. I do enough already for Sonora and my son.
Okay. I'm going to overrule that objection and admit this into evidence. And do know, sir, you'll get a chance to explain why you don't believe back child support is appropriate. State's Exhibit 1 is admitted, and you may continue, Mr. Dehmasian.
Judge, I pass the witness, Ms. Fleeton.
Okay. You may call your next. Oh, actually, Mr. Millard, do you have any questions for Ms. Young-Fleeton?
I only object to this proceeding because I moved to dismiss. There's no reason for this. And
there are clearly many reasons the court is involved here, and the total owed explains why the case is serious. In simple terms, better choices in the past could have prevented reaching this point. If more attention had been given to responsibilities and obligations instead of careless behavior, the situation likely wouldn't have escalated like this. Now it has become a legal and financial issue that must be addressed properly through the court process.
Any questions for Ms. Young-Fleeton?
No, ma'am.
Okay. You may call your next witness, Mr. Dehmasian.
Thank you, Judge. I call Mr. Millard. Mr. Millard, can you state your name for the record?
Sydney Millard Bay.
Mr. Millard, what do you do for a living, sir?
I have a question. I'd like to know the proper names for yourself, the judge, and the other officer that was here.
Judge, objection, non-responsive.
I believe that there's a conflict of interest here because at least two of you work for the state.
Okay. I'm going to overrule the objection. My name is Judge Jennifer Baker. Mr. Gary Dehmasian, his name is written right there on the screen. Miss Tosiana Young-Fleeton, her name is on the screen as well. So you may proceed, Mr.
And who are they employed by?
Sir, it says they work for the Office of the Attorney General. You may proceed, Mr. Dehamajan.
Sir,
So everyone works for the Office of the Attorney General?
I don't. You may proceed, Mr. Dehamajan.
Mr. Millard, what do you do for a living?
So you work for the state?
Objection not responsive.
Sustained. Sir, please answer the questions.
I don't work.
Are you retired?
I don't understand. I don't understand where we're going here. I already said what I need to say in this matter, but you guys keep pushing forward. So I'm telling you that I don't want a contract, and you're steady trying to draw me into your jurisdiction, and that's not what I want.
Sir, do you own an 18-wheeler?
I don't understand.
Do you drive a truck for a living, sir?
I don't understand. I don't understand.
Are you refusing to answer my questions, Mr. Millard?
I move the court to dismiss.
I'm denying that request. You may proceed, Mr. Dehamajan.
Mr. Millard, do you live in a home or an apartment?
I live within myself.
Do you pay rent?
I live within myself.
Do you own a car, sir?
I move the court to dismiss.
I'm denying that
Objection.
request. Sir, please answer the questions so I can make an appropriate ruling in your case. This is not a contract. International Shoe says I have jurisdiction of you. You were served in Texas. This child lives in Galveston County. We are proceeding with the Attorney General's petition.
I don't understand.
Do you pay rent, sir?
I don't understand.
Do you have a car?
I don't understand.
Judge, the witness is refusing to answer questions.
He's saying he doesn't understand. He might not understand. Just ask your questions to the best of your ability, and I'll make my ruling to the best of my ability.
Okay.
You can impeach him if you have impeachment evidence.
Mr. Millard, do you own a phone?
I don't understand.
What are you using for Zoom, sir? What device are you using?
This is a tablet.
Okay, so you own a tablet. Do you know what a phone is? Do you know what a telephone is? Maybe he needed to use the full word.
Do you own a phone, sir?
I don't understand.
Which part of that did you not understand so he can break it down for you?
Any of it. Like I don't understand these proceedings. I don't even understand why I'm here. Like I told you guys that I don't want a contract.
Yes, because child support is a legal obligation that must be paid. When someone is ordered by the court to provide support for their child, it is not optional and cannot be ignored. These payments are meant to ensure the child's basic needs are met, including food, housing, and education. Failing to meet those responsibilities leads to legal consequences and increases the amount owed over time.
Otherwise, I'm just going to make my ruling.
Evidence of what? Of what? That I'm here?
Before me, sir, I can't give legal advice, but I can let you know the issues before me are conservatorship, possession and access, support, child support, medical support, dental support, and back child support. So that is what I'm going to be ordering today.
And I already do all of that, John. So I object to this whole thing.
I understand you object, sir, and I'm overruling your objection. Mr. Dehamajan, do you feel you need any more testimony from Mr. Begg?
No, Judge. I passed the witness.
Okay. Do you have any other witnesses?
I recall Ms. Blake just briefly.
Okay, you may do so.
Ms. Blake,
Yeah.
Do you? I mean, you could just answer to the best of your knowledge. Do you know if Mr. Millard lives in a home or an apartment?
I think he live in a home.
Do you know? Do you know if he? How many vehicles does he have?
No, I don't know.
Okay. Pass the witness, Your Honor.
The state does not represent either party, so I'm going to give you each a chance to let me know if there's anything additional regarding those issues that I just described. Ms. Blake, is there anything additional you'd like to say?
No, ma'am.
Okay, thank you. And Mr. Millard, is there anything additional you'd like to say?
Yes, I'd like the court to move to dismiss. I object to all of these proceedings.
I'm going to make my ruling and render based on the testimony presented. Before I rule, I'm letting each party know that you do have a right to a de novo hearing before the referring court regarding any decisions I make. That request must be filed with the district clerk's office. I am finding, once again, there is jurisdiction over this matter. The child lives in Galveston, and Mr. Millard was served in Texas. Those service papers are on file with Galveston County, as reflected in my previous ruling. I'm appointing the parties joint managing conservators, with Ms. Blake having the right to determine the primary residence of the children within Galveston and contiguous counties, or any county that touches Galveston. I'm setting child support based on minimum wage. There's one child before the court and no others. I'm finding that nobody has access to private insurance at a reasonable cost. I'm ordering that Mr. Millard pay to Ms. Blake cash medical support of $35 per month beginning May
Objection, Your Honor.
2025. Sir, let me get through my ruling. Beginning May 1st.
I have a question.
Sir, let me get through my ruling and then
I have medical insurance for my son.
Okay, you did not testify to that, and you said it was you. I think you might have objected to the question. Where do you have medical insurance available?
I didn't hear the question.
Okay, what insurance? How do you have insurance for your son? Is it through a job? Is it through the marketplace? Is it through a relative? Is it?
Proceed, Your Honor.
No, this is important. Where is the insurance from? I don't know.
It's through a marketplace.
Okay, so you have gone on the marketplace and you purchased insurance? Is that true? That's what you're saying? You went online and purchased insurance, or you called and purchased insurance?
Yes.
Okay. What company is that through?
I don't know. I don't have the documents in front of me.
Have you provided Ms. Blake with those documents so she can use the insurance?
I did.
Okay. And do you know how much it costs per month?
I don't remember.
Is there a place you could go to look that information up? It will affect your child support, and it will make your child support lower. So it will help you to look up this information.
I don't know, Your Honor. I don't have the information with me right now.
Okay. Are you in your house right now? You don't have it anywhere in your house?
Go ahead, Your Honor.
Ms. Blake, do you know that he has private insurance? Ms. Blake, has he given you the cards? You have to answer out loud.
Hold on. Let me look on my phone before I say. Okay, it's what is this? I have a card he sent me. It's a discount card. Hello?
We're listening to you, ma'am.
Ma'am?
We're listening.
Oh. Yes, I pulled up a card. That he sent me, but it doesn't have a amount on here. It just says benefit level, individual, children, the group number,
What company?
member ID, NCE.
Are you serious? Do you actually think handing over a medical discount membership is the same as providing real health insurance? That kind of card usually just offers reduced prices at certain partner clinics, when you pay a monthly fee. It is not actual health coverage and does not function like insurance that protects against medical costs. Health insurance involves proper coverage, benefits, and financial protection, which a simple discount program does not provide.